opportunity to explain discrepancies between his sworn May 15th testimony before Congress that he had never even heard of the potential prosecution of a reporter for doing his job, and his decision prior to that testimony to authorize a search warrant for the emails of Fox News reporter James Rosen, calling Rosen a criminal co-conspirator who faced potential criminal liability in the application for that search warrant. They want those two pieces of testimony squared. Joining me now, Wisconsin Republican Congressman James Sensenbrenner. He's a member of the House Judiciary Committee and the author of the latest letter to the Attorney General, Virginia Republican Congressman Robert Goodlatte, who is chairman of the House Judiciary Committee. Gentlemen, thank you both so much for being here. And so now you had written initially to the Attorney General saying, you testified before us, explain this discrepancy. You got a letter back from an underling saying, it's all good. You know, we've told you before, we never actually prosecuted Rosen, so everything was consistent. Even though he said he never heard of potential prosecutions, our explanation for that testimony is we never brought an actual prosecution. And now you've written back and said, that's not good enough, and you want Eric Holder to go before you. Let me start with you, Chairman Sensenbrenner, or Goodlatte. You're both chairmen, so I'll just refer you as Congressman for this interview. Your thoughts on why the AG needs to come back before you now?
Well, first of all, the letter that we received from the Office of Legislative Affairs did not answer all of the questions that we addressed to the Attorney General, and they were not answered by the Attorney General. He testified under oath on the record. We want the answer from the Attorney General. Yesterday, yesterday afternoon, early evening, we received a letter from the Attorney General incorporating the answers from the Office of Legislative Affairs into his own letter. However, it still doesn't answer all our questions. In fact, it raises more questions than we asked, because essentially now the contention is it's okay for the Justice Department to accuse a reporter of a very serious criminal action. They said that they had probable cause to show that he was at least an aider, abettor, or co-conspirator in violation of the Espionage Act. That raises serious concern. Number one, that it doesn't square with what the Attorney General said. But number two, that seems to be an inappropriate way to get a search warrant, be able to rifle through the chief Washington correspondent of a major national news organization's emails in order to see what's going on, even if they're claiming they're investigating somebody else. But if their charge is correct that he actually was a co-conspirator in spying, why weren't they prosecuting him? I think it was done for the purpose of getting access to the emails that they wouldn't have been able to get otherwise, and therefore we have a lot more questions for the Attorney General regarding his statement and how it doesn't square with the facts of that case.
Congressman Sensenbrenner, Eric Holder gave an interview to NBC News yesterday, and he said, well, that phrasing where we called Rosen a criminal co-conspirator was necessary in order to get the search warrant. And speaking to your colleague's point, he's right. That phrasing was necessary for them to get the search warrant, but there is a reason why the law requires him to assert that a reporter has behaved in a criminal fashion before it will give him a search warrant. And for him now to turn around and say, well, it was all really kind of baloney. I mean, that's essentially what he's trying to say. We never meant it. Does that undermine the validity of the search warrant? Does it undermine the trust between our top law enforcement officer and the court?
Well, it certainly does. And the actual request for the search warrant was for much more than the emails relating to whatever information or contact Ms. Rosen had with Mr. Kim, who is under indictment for violation of the Espionage Act and scheduled to go to trial very soon. The second thing is that this has been kind of missed by the news media, is there was an actual allegation that there was probable cause that Rosen himself violated the Espionage Act and was not just an aider, abettor, or co-conspirator. You know, the fact is that the material the Justice Department wanted could have been obtained by a subpoena rather than a search warrant. And Justice's regulations on the issuance of subpoenas directed toward the news media requires Justice to negotiate out with the news media the scope of the subpoena before the subpoena is issued and served. And they decided to take it up one step further and actually accuse Rosen of violating the Espionage Act. That is a chilling because nobody is told by a leaker that the material is classified. And if the reporter is doing his job, the reporter will follow up on it. And to say that you might be accused of violating criminal law by following up on information that is news means that the news reporter can't do his job.
Yeah, but as you point out, that's the reason he did it, because he wanted Rosen's records and he didn't want to notify Rosen in advance. It's much, much easier to get what you want from a court when you have no adversary on the other side arguing against it. But I want to ask you about whether this Attorney General has answered the question directly, and if not, why not, Mr. Gillette? Because he came before your committee, and I hope the viewers will bear with us, because it's worth playing for them again what this Attorney General represented to you directly. We had heard about the AP scandal. We didn't yet know about Rosen, but he did. Eric Holder did. And knowing that he had labeled him a criminal co-conspirator, identified him as a flight risk, said he faced potential criminal liability in an FBI search warrant affidavit, he told you this.
With regard to the potential prosecution of the press for the disclosure of material, that is not something that I've ever been involved with, heard of, or would think would be a wise policy.
And Congressman Goodlatte, his response to your questioning, saying, how do you square that with your knowledge about what you did to Rosen in this letter is, prosecutors have not pursued charges against that reporter, Rosen. So the AG's testimony was accurate.
Well, it's not accurate when you use the phrase potential prosecution, and it's not accurate, in my opinion, when the Attorney General has signed off on a warrant that clearly accuses Rosen of committing a crime, and even goes so far as to go to 3 different judges before they can get a judge to agree to seal the warrant. And in the effort to get the judge to seal it, one of the reasons they gave was that they considered him a flight risk. Well, if they weren't thinking about prosecuting him, why would they be worried about him being a flight risk?
How do you get him
There's a lot to be answered.
My apologies. How do you get him to come back before the committee? It's an invitation that you've extended to him, Congressman Goodlatte, but does he have to accept? What happens next?
We'll take it one step at a time, but we think it's very appropriate that the Attorney General come back. There are lots of issues related to this and the overall policies with regard to the Justice Department in terms of investigating reporters, investigating leaks. And by the way, both Chairman Sensenbrenner and I believe it's appropriate for the government to investigate leaks that jeopardize national security, but they've got to follow the rules. They've got to protect the rights of reporters and respect the First Amendment, and all of those questions are very appropriate given the Attorney General's answer, which doesn't square with the facts.
And I want to ask you, Congressman Sensenbrenner, save you for the last, because just on a different matter that's in the news today, and that is this whole NSA story and the fact that they've now got the cell phone or the phone records of millions and millions of Americans. We've had a lot of folks come out, Republicans and Democrats, who've said this is not a big deal. This is what the NSA does to preserve records in case they need to conduct a sweep for terrorist records. And this has been going on for years, and it's being overplayed. Your thoughts, as the man who authored the Patriot Act?
This is a big deal, a really big deal, because the business records sections of the Patriot Act were designed for specific investigations against specific individuals. I would see nothing wrong with targeting the phone records of somebody who is suspected of terrorism. But everybody who either sent or received a call from a Verizon phone and maybe the other cell phone providers, that was never the intent of the business records section. The business records section is set to expire in 2015, and I want to find out why they decided to have such a broad brush to bring in everybody. And if we have to amend the Patriot Act before 2015 to stop this from happening, I am all for doing the author of the act.
And Megan, let me add, if I may, I agree with Chairman Sensenbrenner. This is something that, if of the administration, this could apply to any administration. It should have been debated in the fashion that they wanted to keep all of these records in this fashion. If that's indeed their purpose, that should have been a part of the debate in the Congress. And believe you me, as we find find out more about this. It's our intention to get the facts and have that debate and change the law if necessary.
Yeah, you got a lot to talk to the Attorney General about. Chairman Sensenbrenner, Chairman Goodland, thank you both so much for being here, sir. A lot of news there. We're going to repost that as well on foxnews.com/America Live.